Hello, thank you. I just need to respond to the CMA's ground 3. If we go to the core bundle at page 5, the core bundle at page 5, so we just identify it. So page 5 of the core bundle, tab 1. This is issue 3, duration prior to the second written agreement. Did the CAT in H3 in setting aside the decision regarding the alleged 10 MIG agreement in the period before the second written agreement? And as the court will have seen, essentially the point is made that Mr. Baton was not very much involved in 2013, and therefore, even if the allegation of dishonesty was not put, it only concerns the second written agreement, not the first. So I just want to quickly show Mr. Baton's involvement, and then also show the court a couple of passages on Mr. McEwen.
Which page was ground 3?
Issue 3, page 5.
Issue 3.
Issue 3. Well, it's issue 3 and ground 3. So
Yeah.
it's issue 3 of the list of issues.
Yeah.
So page 4 of the core bundle is the list of issues, and I've dealt with a few of them in ground 2, and then the CMA had a separate ground 3, which said, well, because Mr. Baton wasn't really involved in 2013,
Yeah.
there's no the tribunal erred. We say it didn't. Just to show Mr. Baton's involvement, I mean, we've seen this in spades with his evidence in the same bundle in the decision at page 540, paragraph 338. So in the same bundle, my 540.3.38. We see there that the decision, it says it's fundamentally about the conduct of a few individuals. And if we go to 541, we see that Mr. Baton is one of those key individuals. And we see that at F, G, H, and I. So the short point here is that the CMA itself says that Mr. Baton was a key individual throughout the whole of the infringement period. And just for the court's note, he was asked essentially whether he was a key individual, and he was asked whether he was in charge, and he accepted in cross-examination that he was very much in charge in 2013, and that is at day 2, page 478, line 17. Day 2, page 478, line 17. He accepted in cross-examination.
I need a page number if you want.
Page 478.
Of the supplement.
Of the agreed supplemental bundle, sorry. Of the agreed supplemental bundle. Page 478, day 2. And it was put to him, you were in charge in 2013. He agreed that he was very much in charge. So, and if one looks at the content, and I showed the court some documents whenever it was on Thursday, and he is on many of the documents, responsible for terminating the supply arrangements with Auden, and responsible for launching its own product in January 2014. So he was at the coalface throughout the whole of the period. And it's difficult to understand how the CMA can really pursue that factual point. Can I just make a couple of points now about Mr. McEwen, because he has been referred to quite a lot. And I just
don't
need
understand. I may be being stupid. I don't understand what factual point they can't pursue.
But Mr. Baton wasn't involved in 2013.
Right. They say he wasn't involved.
Yes. And essentially it was Mr. McEwen, there was a changeover, And Mr. Baton was only responsible for the negotiation of the second written agreement. And we say, well, when you
He
look...
never took instructions from Mr. McEwen and never had conversations about the past.
That's essentially what they say.
That's what they say.
And he was very much in charge. He was very closely aligned with Mr. McEwen. Mr. McEwen was closely aligned with Mr. Sully. And I just want to show the court a few documents which show the perception of Mr. McEwen and how the documents don't show that he understood there was any pay for delay. Because at the moment it's being put, Mr. McEwen was the evil person, he negotiated the unlawful agreement, pay for delay. And when one looks at the documents, it doesn't show that at all. And again, I've only got a few minutes to do that, but it's important that the court realises that that's my submission. And so with that, could we go to the unagreed supplemental bundle, the unagreed supplemental bundle. Volume 2, we're going to go to Volume 2 and 1. Volume 2 and 1, but it's the unagreed supplemental bundle. And I'd just like to pick it up at page 994. This is tab 16 of the unagreed supplemental bundle, Volume 2. Because Mr. Turner has asked this court to make some adverse inferences from Mr. McEwen's involvement and lack of us calling him. And I just need to show the court where we address this in our oral closing. So this is at page 994, at line 10. Before I move to the next item, the next bullet, which is the involvement and senior management, can I please just give the tribunal my 5 reasons why the CMA is wrong to ask for adverse inferences to be drawn. The first is that he was under the supervision of Mr. Baton. That's the first, that's line 15. Second, he left his employment in early 2014, over 8 years ago. Over the page at 995, at line 14, I give a third reason. So the second was he left his employment in early 2014. The third reason is that CMA has already been able to cross-examine him twice in 2 separate interviews under caution. And we know that it is a serious caution, and that's what we described there. And then over the page at 996, this is internal 17, the fourth reason I gave is the CMA prepared a witness statement upon which it relies in the decision, and if there is any aspect of the statement the CMA does not like, it could have asked the tribunal to compel Mr. McEwen. So the CMA actually got a witness statement from Mr. McEwen, and it complained that we hadn't called him very late on in the day after the PTR. And then the fifth point that I made, why adverse inferences should not be drawn, is because the tribunal is very reluctant to do it. We argued it should have been done in Fenatoin when the CMA didn't call any Department of Health witnesses and the tribunal declined. So it is a very rare occurrence to draw adverse inferences from a party's failure to call a witness. One simply doesn't know why that witness cannot be called, particularly 8 years after he's left the employment.
I think we said we had a few stray observations about this point in British Telecom and Royal Mail against DAF. But anyway. I just don't want to...
In which we said you could draw adverse inferences.
Well,
Depending on the
It all
facts.
depends on the circumstances.
yeah, depends on the circumstances.
Yeah.
This man left 8 years previous,
And he'd been questioned twice.
and he's been questioned twice, and
And that transcript evidence is admissible anyway as part of the evidence.
they rely on the transcript evidence, and they rely on the witness statement that he signed for the CMA. So,
Yeah.
can I just very quickly now just go to volume 2? No, so volume 1 of the unagreed. we can put volume 2 away. And this is our written closing. I just referred to our written, our oral closing. This is our written closing
What
at
page?
tab 14. So we just start at 668. Tab 668. This is in our written closing. And it's under the heading at 668, evidence showing that the 10 MIG agreement did not exist. In the closing, we set out some of the key documents which show that the agreement did not exist. They're all set out in that Annex 1, but we can see above 37, the period 2012-2014. We go over the page to 670, and again, I do understand that I'm just taking the court to a few documents, but 670, we see there halfway down on the 5th of February 2013. And this email is all about AMCO wanting expedition of the development, bless you, of its own product. And a meeting was held at which Amdi Farm requested production of a batch, was not pleased with the earliest production date, is shown by an internal email. At the meeting, Amdi Farm had requested ASICA for its earliest production date. And we go on, and then the bit in bold is the bit I just refer to. This is from Mr. McEwen. The response from Brian McEwen of Amdi Farm, who the CMA says was instrumental in alleged 10 MIG agreement, stated, Wayne, this is Wayne Middleton, one of our witnesses, many thanks, appreciate your efforts to expedite. So this was a contemporaneous document from Mr. McEwen thanking the development team for trying to expedite production of their own product. And again, it's important to put Mr. Turner's submissions in the context of this sort of evidence. And then lastly, if we go to 881 of the same bundle, this is an annex to our closing. On 881, we set out some of the evidence relating to Mr. McEwen, who was under the supervision of Mr. Bayton, terminating supply with Auden, trying to get development of the product done as quickly as possible. And we see paragraph 5, 6, 7, 8 and 9. So could I end by just looking at the document on page 884? So the document at 884, we identify in paragraph 9, which is the Pinsent Masons Competition Audit Report. But this is relating to the first period. And Mr. Sully is asked who would have been the person dealing with Pinsent Masons. And he says in cross-examination it would have been management, it would have been Brian McEwen. And we see that in paragraph 8. So this document is recording what Mr. McEwen told Pinsent Masons about the company's strategy. And it's the bit in yellow, it's not confidential, but it is important to see what Mr. McEwen told the external solicitors. So this is all part and parcel of the competition law compliance audit. When questioned, the management of Amdi Farm has explained that the rationale for Amdi Farm to continue to source hydrocortisone is twofold. First, because Amdi Farm does not have a supply of its own, and secondly, Amdi Farm is not convinced that ASICA will be able to manufacture the product according to specification and or consistently. We understand that ASICA has been developing this 10 MIG formulation for some time, but has not yet produced any compliant batches. And then we put this in bold. The development project is still underway, and the management of Amdifarm, that's Brian McEwen, have explained that the strategy is to continue to source from Auden until Amdifarm has its own supply source, when it will switch over to that source and be able to act independently. That is what Brian McEwen told the external solicitors. And then over the page, 885, second, because Amdifarm has not been able to assess whether its Asica hydrocortisone line extension, if successfully manufactured and capable of being marketed, would be able to compete with the Auden product in circumstances where the Asica developed Amdifarm product does not have the key adrenal insufficiency, that's the adult's indication, due to the OD orphan designation status. Therefore, Amdifarm has been selling Auden product in order to maintain a foothold in the hydrocortisone market while it creates a validated supply source of its own and while it assesses how to deal with the OD issue. So that is the company strategy that Mr. McEwen informed its external solicitors, and this is recorded, this audit, the competition law audit, is dated the 27th of January 2014, and I showed the court the minutes of the board meeting on the 29th of January last week, where the board decided to terminate the supply arrangements with Auden and go it alone with its own independent product, notwithstanding the orphan designation issues, because it felt that things were looking rosier. So this is a competition law audit, and then 2 days after this, the board actually decides to terminate supply with Auden and go it alone. And that is consistent with what Mr. McEwen told the external solicitors. But I just need, the court needs to know that your adverse inferences.
But it didn't.
But the tribunal didn't.
No, it didn't. Did it terminate the arrangements with Auden?
Oh, it did?
For a while, for a short while.
Well, can I just explain that?
It entered into the first written agreement in February.
It terminated the supply arrangements. The decision, we've given you the passage in the decision, which says, and not to be renewed. So there is a finding in the decision that AMCO terminated the supply arrangements, and we rely on the statement in the decision, which says, and would not be renewed. And then what happens, so having made the decision to launch, having made the decision to terminate supply, as one sees from the witness statements and the documents, in April, May, they still don't have guaranteed supply from Asica, and AMCO's customers said they're not interested in it. And so that is why we get the paragraph in H2, I think it's paragraph 144, where you have the triple lock, you have, I'm out of stock, my customers have said I'm not interested in it, and I have no guaranteed supply. And so that was the factual context for the 2014 agreement, as the Tribunal H2 says, and that fact is not appealed by the CMA in the current notice of appeal. There is an uncontested fact that in June 2014, AMCO had the choice, resume supplies, or leave the market. So, again, to repeat what my lord said earlier on before lunch, one has to look at the factual background at each stage of the game. The factual background in January 2013 is not the same factual background as it was in June 2014. And the tribunal at H2 doesn't really grapple with the different factual background. But it did terminate, it did decide to go it alone, but then because of demand and supply, didn't have a guaranteed supply at that time. It had demand issues from its customers, and it was faced with a choice: leave the market or resume supplies. So I've taken it to.
Thank you. Mr. Tanner.
May it please the Court, I will divide the CMA's responsive submissions with Professor Bailey. Lots been said. I will confine myself, Mr. Bailey will confine himself to what we consider to be the major points emerging from the company's arguments. We'll organise our points as follows. I'll start, and the first thing that I'll deal with is the major procedural question on which, my Lord, you asked for submissions and which Mr. Jowl addressed this morning. And in a nutshell, using your expression from day 3, my Lord, the concern is that the tribunal approach things back to front by deciding the case or resolving the case in H2 and only then addressing whether there was a problem with what was put in the cross-examination. The court will already have picked up from the due process judgment, H3, that the CMA submitted at the time that this was the wrong approach. The tribunal responded in H3, and the court referred to this before the short adjournment, at, in particular, paragraph 68 for Roman 3, that in fact it was the CMA's conduct which had resulted in the need for it to go about things in the way that it did. The tribunal said that we had insisted our case had been properly put by counsel, which, in the tribunal's words, forced the tribunal to decide the case on an incomplete record. So I'm going to cover that first. Second, it's most efficient to deal with Miss Ford's submissions on what is in the list, issue 1D. That is her argument that the CMA's case, as it was put, did not grapple with the supposed need to prove a subjective meeting of minds between Mr. Baton and Mr. Patel in order for there to be a competition law agreement. She argued that what had occurred was consistent with there being only unilateral behaviour on both sides of the table. Today, she ran through a number of emails that the CMA relied on in its case and in the trial, and she made submissions on those individually in a salami slicing fashion, and I'll look at that too. Her argument ran together with, converged with, an argument from Mr. O'Donoghue, which you'll recall was that the CMA originally proposed a different case theory in 2017 in its statement of objections. And that focused on the written agreements and found them objectionable because they incentivized AMCO not to enter the market independently, but instead to share in Auden's monopoly profits. Mr. O'Donoghue submitted that by focusing the case differently, the CMA has said, in his words, loud and clear, that the written agreements do not disclose a breach of competition law. It's day 3, page 34 of the transcript. Third, then, I will turn directly to Mr. O'Donoghue's argument that the written agreements were not treated as unlawful by the CMA, and that the CMA failed in these proceedings because it did not identify what was the unlawful add-on, nor did the CMA's counsel cross-examine Mr. Baton on the difference between lawful written elements and unlawful unwritten elements. At that point, after those major arguments have been covered, I'll hand over to Professor Bailey, and he will address you on the question whether the wrongdoing continued after May 2015, when Mr. Patel left, but the arrangement continued, or after September 2015. Fifth, and conscious of the time, I will sweep up at least one of the company's main arguments about the failure by the CMA's counsel, Ms. Dimitriou, to challenge key points when she was cross-examining Mr. Baton. Now, in response to the Master of the Rolls asking for a single sheet of paper summarising what they had said last week at the hearing, we received, and the court will have, a 4-page note with 8 allegations. You have that if it found its way to the members of the court. And I'll make one observation about it straight away, if you have it there, and cast your eye over the points, issues 1 through to issue number 8. What I would ask the court to do is to compare this new list with the list that the companies jointly produced for the tribunal after the due process hearing, which followed the hand-down of the H2 judgment. You will find it in the unagreed bundle at tab 77.
Which one is that? Line 3.
It's my 4th volume, unagreed bundle. It's, at least in mine, it's the 4th volume. It's tab 77, and the page number is 2095.
Yep.
So this was when the respondents at that point were asked to summarise, akin to what the Master of the Rolls asked at the end of last week. What were the questions that should have been put by the
This
CMA?
after the H3 hearing or before the due process hearing?
After it, yes.
After
After the
before
H3
judgment.
hearing.
Is that
Yes.
right? 13th of November.
Yes, that's right.
Yeah.
And
And
it's
so
only
this
on
is-
dishonesty.
Well, that's the point, yes. First point, you heard what Mr. Giles said about the construction of what the concerns were, and you'll see that this is referring specifically to sham dishonesty in the title, and all of the questions there are concerned, and they make a good read, but all of them are concerned with failure to put points going to dishonesty. And it will be instructive for this court to compare that with the document you've now received. In my submission, and to follow Lord Justice Green, it makes a telling point immediately because it shows the understanding of the H2 judgment and what it considered was the unresolved concern. Mr. Jowl told you this morning that paragraphs 25 of the H3 judgment, and I think it was 1573, only referred to concerns about the CMA having not put the case. Lord Justice Green said, well, what about the other part of the judgment which concentrates on dishonesty? Shouldn't it be read together? And our submission is, of course, it should be read together with that. And dishonesty was the single concern in the H2 judgment. You see that implicitly from the way that it was approached by the companies at this point. In this document, you will see repeatedly the language of cover-up, charade, sham, connivance, deception. Now, in the light of the H3 judgment, and in the context of this hearing before the Court of Appeal, the companies have deployed a series of wider points about the supposed failure to put questions which go to the very nature of the common understanding about staying off the market. And if I may use a phrase that the Master of the Rolls used, a battalion of angels is now marching onto this pinhead. Had the issues now raised on the other side really amounted to fundamental failures of the process, rendering the trial unfair, which is the heart of their case, you might have expected the companies to point this out sooner.
The judgment in H3 was about 4 or 5 months after this.
Yes, the judgment was March. This is November, so 4 months. If time permits, I will cover one of the points specifically that were raised by my friends before this court as a failure to cross-examine on the nature of the case. And that is the one that Mr. Brearley devoted a great deal of time to in his opening submissions. That was the notion that Mr. Mitru fatally failed to cross-examine Mr. Bayton on AMCO's internal commercial rationale, not in the period when he was involved in the negotiations himself. He came in the spring of 2014, but in the earlier period, before the negotiations over what's called the second written agreement.
Yeah.
Sixth, and finally, I propose, I will deal briefly with the attempts by Mr. Brearley in particular to persuade this court to revisit elements of the factual evidence before the tribunal in different ways. You had a flavour of that just now, and earlier there was the reliance on exchanges between AMCO and Pinsent Masons as evidence of dishonesty within AMCO. And I will seek to pick up the adverse inference point that he closed on at that point. And then I will conclude. Before I then begin with the major point that the Master of the Rolls has asked us to address in
So
submissions.
do they get another bite at the cherry after you've concluded?
They have, well, they've technically run out of road, but assuming that I do this within time, we had discussed between ourselves that they may have 45 minutes or so to come back on what I say at the end.
This is on, notionally, it would be on their respondents' notice points.
It will be on their appeals,
On their appeals.
On
yeah,
their appeal.
where I'm responding to them.
Yeah.
And
Yeah.
Okay.
But they don't have any more road on your second appeal, i.e. the process appeal.
no, I don't want to be put this into a straitjacket, and the court will obviously do what's fair, but that is technically correct.
Can I just, I was intending tomorrow just to respond to the CMA's appeal, which I haven't dealt with yet.
Your 4-page note.
No, that's the
No,
opposite.
no,
But it's essentially, my Lord the Master of Rolls said, what is the legal point concerning H2? And I was going to come back on that after what I heard Mr. Turner submit on the legal point on H2.
Okay. Well, within reason.
May I begin with...
We have to finish tomorrow at 4:30, right?
Yes,
And that's a dead stop.
so I...
And as the Master has already indicated, our commitments are such that we can't start before 2. We may even find
Not
ourselves
make
slightly
it.
later.
We'll do our best.
I entirely understand that, and I hope members of court will understand that on my side, therefore, there will be a degree of selectivity in the points that I address, and that I can't cover everything. But what I need to begin with is to remind the court of the legal framework, because one of the big questions facing this court is, how do we deal with this problem? What's our powers and what is our role? Ms. Ford took you to one of the provisions earlier this morning in the Competition Act. I may ask you to go back to that in Authorities 1, tab 3, and look at page 39. I just want to remind you of how this all is meant to work. The CMA, the administrative authority, makes its decision. There's then the appeal on the merits to the Judicial Tribunal. The relevant provision that I want to refer to on page 39, under the heading Decisions of the Tribunal, this is in Schedule 8, is paragraph 3 to E. The Tribunal may confirm or set aside the decision subject to the appeal or any part of it, and may E. make any other decision which the CMA could itself have made. So there you see the foundation of the merits jurisdiction and the latitude that they have, provided that a fair process has been observed. steps from there to what your powers are, and you will know this well. If I go to a case in which the Chancellor and Lord Justice Green were both
This is Evans,
sitting,
is it?
Evans, yes,
Yeah.
it's Authorities 4, tab 62. And in it, on page 2308, the relevant paragraphs of 160 and 161, both sidelined. In paragraph 160, near the top of the page,
Sorry, which page is it?
2308 in the authorities bundle.
That's pressed in mine.
Tab 62.
Yeah.
Yeah, it's paragraph 50, sorry, section 15, subsection 3 of the Senior Courts Act, isn't it?
Yes,
Effectively, the Court of Appeal has the same power as the tribunal. From
That's
which,
it.
Court of Tribunal from which the appeal.
yes. So the tribunal can substitute its own decision for the CMA, make a decision that the CMA could have made. You have the same powers as the tribunal below does. And so when you're deciding how to resolve this, my submission is going to be that if what you have before you is a case where essentially the facts have been investigated by the tribunal below, and where what you do not have is a lack of clarity or further facts requiring to be investigated, which might be the correct province of a retrial, the right course for this court will be to grasp the nettle and to make your decision whether the decision should be upheld, taking into account the findings of fact that have been made by the tribunal. And in that regard, our submission is that this is a case where, shorn of the dishonesty red herring, the findings of fact in H2 are robust and stand independently in the way that I described in opening submissions. Attention was focused heavily this morning on paragraph 1448 in H2, which we need not open, but you'll recall is the one where the tribunal refers to the conversation and refers to the maintenance of prices at around the level that Auden was charging. We say that it is clear that that provision, that paragraph, cannot support the weight which the companies are seeking to attribute to it. And make 2 points here. First, and we will have to open the judgments, the tribunal referred to an agreement, conversation about an agreement. It was implicit in the argument this morning that agreement referred to perhaps some express agreement having been reached, the conversation about this subject matter, rather than a nod and a wink. But it is absolutely clear from the tribunal's judgment itself, as the Master of the Rolls rightly picked me up on in my opening, that this tribunal knew very well that when it refers to the word agreement, what it means is an agreement in the competition law sense, and it emphasises this in 2 places. The first is on page 410 in the H2 judgment, which is on a page headed A Question of Due Process. You'll see footnote 20, quoting Professor Bailey's excellent book, and referring to the fact there's an agreement in the sense of the Chapter 1 prohibition is not confined
Sorry,
to...
which paragraph are you on?
It's the footnote 20.
Page 10.
Yes, I'm sorry. It's page 410. It's the footnote to paragraph 10, as Lord Justice Green says. And you'll see that the tribunal there first makes the point that an agreement in the Chapter 1 sense is not the same as an ordinary legal agreement, and it could mean something far looser. And then they clarified that further in the H3 judgment. If you go to page 318 in this bundle, and this again is a footnote 20. It's page 318,
Yeah.
internal page 18.
Paragraph
24.
20, yes. Thank you. It's a footnote to paragraph 24, bottom of the page. And here the tribunal is referring to the fact that an arrangement might fall far short, you see in paragraph 24, of the contractual. Such an arrangement or understanding may be neither formal nor a promise, nor agreement, although they can be. And if you go to the footnote, they now refer to Wish and Bailey, but say even this may put matters too high. It's dangerous to speak of a morally binding commitment when what's at issue is an unlawful infringement of competition law. The point we're trying to get at is that collusion, even informal, nuanced and difficult to detect collusion, is sufficient to amount to an infringement. What is not sufficient, purely unilateral conduct. So my first point is that when they're using the word in 1448 agreement, you cannot give it the weight to say that here they must have been finding that there was a specific articulated agreement. They knew perfectly well that they could have been talking about a nod and a wink. The second point is the price maintenance idea.
you say that, but I do find that very difficult looking at 144 sub 8. I mean, it does look as if it's talking about a conversation in which something was agreed.
Well, absolutely. But then there were conversations, and as my Lord the Chancellor pointed out last week, we know that there were conversations, not least from the fact that in the 15th of June email...
I mean, he uses the word deal.
Yes.
I mean, what if you're wrong about this? And what if this is a finding, that there was a deal reached in a conversation which was not actually put to Mr. Baton, that he had such a conversation and reached a deal? Can this be excised as being surplus to requirements?
Yes, that is where my reference to the framework of powers comes in, because you have all the powers that the tribunal has to make the decision that the CMA could have done. And if you regard this as it is, as an inessential finding, not, as the companies say, the heart of the case, without it, the entire judgment falling to the ground, then you are able to make that decision yourselves under the powers that this court enjoys. And we say the same thing...
as they say. You say the same thing as they say. They say we can decide that the appeals should be dismissed because you didn't put a proper case. Appeals can be dismissed.
You can decide on my side that...
Sorry, appeals be allowed.
That the appeal, yes. Well,
that's what they say, and you say...
absolutely.
We can do what we like.
Well, no. What I'm saying is that there's a sufficient basis here from everything that you've seen to be able to say that when one understands agreement in the sense that the tribunal well understood that it could be a nod and a wink, that here this is an inessential finding, given everything that you've seen about the reasoning of the tribunal in the H2 judgment itself. I make a similar point in relation...
It's a bit unclear what sort of an agreement they're referring to. I'm looking at subparagraph 8.1 and 2. So they refer to ample opportunity and conversations, and then the substance of the conversations they seem to imply were bluffs and threats. It's quite unclear what precisely is being said, or how formal or informal.
Yes.
It is.
No, my Lord, I accept that. May I then deal with the other limb of their point on this, which is price maintenance? The third line of 1448, also that AMCO would take Auden's product and sell it at around the prevailing market price. Now, the Chancellor commented before lunch, well, isn't that obvious? Refer to the fact, which I mentioned in my opening, I think, that if you go 2 pages on, page 485, at the very top of the page, you see at the conclusion of paragraph 147, there the tribunal is talking about the oral agreement. So in short, it would have been important to Auden to maintain a high price across the market. We consider that such a common understanding would have been an inevitable part of the arrangement, so obvious that it would not require express statement. So again,
Well, the last thing Auden would want would be them coming on the market and undercutting them.
That's
the point, isn't it?
absolutely, and that's the thinking underlying the tribunal's decision here, which it develops in various places, particular paragraph 115, where it talks about what is going on, and in relation to Auden's state of mind, that Auden, I mean, if you go to the end of page 463 and just look at Roman 6, at the end of paragraph 115, whatever the subparagraph is, we consider Auden would have been well aware of the dangers of multiple new entrants. In other words, it couldn't rely on this stopping with just one, with price at the same level as it. And in this case, the dangers of a single new entrant selling an inferior skinny label product, because its finding on the facts is that with a skinny label, somebody who wants to actually break into the market is going to have to put a spearhead in at a much lower price. And their finding of fact, their assessment as an expert tribunal, is in the last line, averting this danger by buying off Waymade would have been worthwhile. And just to complete, as Ms. McAfee points out, if you look at sub-paragraph Roman 4, just above that, the last few lines, this would not be a case of a new entrant competitor selling exactly the same product at a slightly lesser price, but the case of a new entrant selling a product encumbered with a disadvantage, the skinny label limit, and for that reason selling at a substantial discount. So their finding of fact as an expert tribunal is that that is the correct dynamic, and there's no reason to go behind that. That was, to follow my Lord the Chancellor's point, the reason why they apprehended that Auden would have had a motivation for trying to buy off the potential competitor. Now, with that, I turn directly to the first topic, the question concerning the tribunal's process, which the Master Rolls raised. And reviewing the hearing transcript from last week, if I may, I'll break it down into 3 main points, which I need to address. Number 1, should the tribunal have proceeded in this way? What was the legal error? Number 2, should the CMA or the companies have gone straight to the Court of Appeal after H2 was handed down, rather than engaging with this further process? Why didn't we? Third point, should this court now dispose of the case itself, or is there a need for a retrial? The point that I've adumbrated. So I'll begin with the question, should the tribunal have gone about things in the way that it did? You'll hear from all sides of the court the same response, clearly not. However, that is the answer that only the CMA articulated clearly at the time, and it is the answer which the CMA gives today too.
Where did you articulate that clearly, please?
I'm going to come to that in just a moment, because I'm going to take you to the places, my lord. Our position is that it wasn't appropriate for the tribunal to reach a decision on the merits of the cases before it, and then go on to revisit those merits afterwards. You asked Mr. Jowl about the legal errors. There are 2 legal errors in my submission. The first is breach of the principle of finality, which senior courts must observe. This is a principle that the Supreme Court first articulated in the Sainsbury's case, the multilateral interchange case, on appeal from this court.
Did we get that wrong?
They said we got that bit wrong. Do you remember?
That was I will avoid.
I didn't.
No, I will avoid flattering this court, but
It was all the then master of the rolls.
there was only one very small point where you were reversed by the Supreme Court.
They said, I think it was I can't remember exactly what it was, but I've come across it since. They said we shouldn't have sent
Sent
the
it back.
Popperwell case back to the CAT because it
On
had,
exemption.
he'd already decided the point.
That's it.
Is that it?
That's it.
Yeah.
It was essentially the principle of finality.
It hurts, I think.
Yeah. It was the Asda case, wasn't it? That we sent back and we got our wrist slapped for doing that.
Only on that, and everything else, it was a
And
tick of
Masterful
approval to
judgment.
everything. Absolutely.
On everything else.
However, what happened was that the Supreme Court in that case then articulates this principle of finality,
Yeah.
says it's a really important point, refers to Henderson and so forth. And then in subsequent cases, and most
give us the
importantly,
reference,
we have in the bundle the AIC case, which I'll take you to show how it's developed there. They refer to that in that connection.
Yeah.
And my submission is going to be that here you have a situation where the tribunal has purported to reach a final decision. It's said that there's a concern about perhaps one area, which is this dishonesty area. But it doesn't then, even if it goes back into the dishonesty question, it doesn't unpick wider elements afterwards.
No, I understood.
That's how we see it. And so my first point is that is a breach of the principle of finality as articulated by the Supreme Court in that way.
Well, another way of putting the same point, I suppose, is to say, well, if they had that concern about due process, I mean, you say it was an unwarranted concern, but if they had that concern, what they should have done is to reconvene the hearing so they could hear submissions about it before
Yes.
they even thought about handing down any sort of judgment.
Yes, absolutely. That there were various ways of
Yes.
dealing with this, rather
What's the
than
second legal error? What's the second legal error?
second legal error is where I joined forces with Mr. Jow, essentially, as I heard him.
Peace has broken out on day 4.
Cheerfulness has broken out across the courtroom, but I want to be precise about the nature of the agreement. And this is that the tribunal should not have made what were expressed as definitive findings on the grounds of appeal. All the grounds of appeal fail. We uphold the CMA's decision on the merits. And then treat the dishonesty debate, the dishonesty issue, as something free-floating and detached from it. That's the curiosity. And may I say, this is not a case of ignoring the cross-examination evidence at the trial and only focusing on the documents. Far from that, because if I may invite you again to go back to H2, what you see is a very close examination in the reasoning of the tribunal of the cross-examination as part of its thinking.
but dealt with in isolation. It's quite interesting how they deal with the cross-examination under the heading of subjective, the subjective approaches of the parties, and they deal with the documents in another section. It's not integrated.
It certainly isn't integrated, but what you do see from
But you're right, they deal with the cross-examination.
but just to show you that it was the dishonesty element in the cross-examination that worried the tribunal that Mr. Mitru had not put. You need to put to this person that you're not telling the truth now and you were doing something that was improper at the time. That was the...
But just before you go there,
Yeah.
you say they made definitive findings that the grounds of appeal fail, and then allow dishonesty to float free. Whereas obviously, if dishonesty, well, I mean not obviously, because if you don't need dishonesty, you can find there was dishonesty or no dishonesty, and you can still find that the grounds fail. So why are the two connected in the way you say they are?
you can find dishonesty or not dishonesty and find that the grounds of appeal fail.
Yes.
Our case is that dishonesty was not something that they should ever have bothered themselves with. And I've explained in my opening submissions why simply going down this road was misconceived.
I know, but your, if I may say so, Mr. Turner, your intellectual analysis, which I respect you for having advanced, is they should not have made the definitive finding that all the grounds of appeal fail,
Yes.
and then treated the dishonesty debate as floating free of that.
Yes.
But why is that when the findings can be, the grounds of appeal can fail with or without dishonesty?
Yes. I think I understand. I'm sorry. It's because in my submission, the tribunal first made an error by considering that dishonesty was an element that it needed to address in order to dispose of the grounds of appeal.
The preceding point is that they had recognised at this point that it wasn't necessary.
They'd already
In
said
the
that.
judgment, they said it wasn't necessary, and then they decided it was necessary.
They decide
Nobody says dishonesty is relevant to breach in this case.
They decide, yes. So in the H2 judgment, they say that dishonesty is not formally an element of the infringement.
And then it becomes, quote, central.
Then it becomes central, but it's because they say in this particular case, given the nature of the allegations being put,
Yep.
it is hardwired. And their twin reasons for doing that are it's essentially misconduct, the intentionality point, that needed to be put. And the second point that on the facts, you committed less to paper in the second written agreement than there was, and that was essentially furtive, improper conduct.
But isn't it boiled down to it's simply an error of law to recognise dishonesty as relevant in any way, shape or form?
Yes, it is. Well, absolutely. That our case is that was an error, and therefore, in answer to the Master Rolls, I am really seeking just to. I'm not endorsing that dishonesty, free floating above the waters, is something that ever should have been taken into account or ever should have preoccupied the tribunal in the way that it did. However, from its perspective, it made the legal error of considering it was something that required to be covered by the CMA's counsel at the hearing because the witnesses were present. And then what it did was to commit what I've referred to as the second legal error of making findings on the grounds of appeal and treating this, although in its own mind it is related to it and necessary to determine it, as a detached element which could be considered separately.
So is this another way of saying that it wasn't appropriate to bifurcate a judgment between different parts of the evidence because it's a single unitary exercise to evaluate the evidence, and you can't make findings on bits of the single unitary evaluation and ask for further submissions on other bits?
In part,
But that's what Mr. Giles said,
It
word
is.
for word.
It is. The reason why there might be a difference between us is because the bit that I say that he hived off and shouldn't have done
Is dishonesty.
was dishonesty.
Well, that was his second point.
And I want to make it quite clear that that was the error made by the tribunal. And the reason why I emphasise that is because once you appreciate it and you see that this is essentially a discrete topic that it got worked up about the tribunal and should not have been concerned about, it's something that you will see that the rest of its findings made in H2 leading to its conclusions before it goes on to the dishonesty concerns, you will see that those stand independently because all of the reasoning process that it engages in to reach its finding that the grounds of appeal fail is unexceptionable.
Are we not, is all sides not saying the same thing? Whether you call it finality or you call it bifurcation of factual findings, or whether you call it breach of the due process of fairness, a tribunal cannot make provisional findings of fact and then say they need submissions, further submissions on bits of those findings of fact, however, provided they're relevant at all. Now, you may disagree about how relevant dishonesty is, but what they did here was they made some definitive findings of fact and then said, but we need more submissions on bits of the findings of fact.
Absolutely.
And that's what's wrong, is it? I mean, you're both saying that, as far as I can work out. So it could be right. Who knows?
Yes, we are both saying that. The question of emphasis, and I'll move on, is only that I say that the part that was preoccupying the tribunal, which it needn't do, which it left over, is something which you can treat separately, and you can look at the reasoning chain that it engaged in the judgment up to that point.
Well, you're dancing on this pinhead because you don't want to throw the baby out with the bathwater, and they're very keen to have the baby chucked.
Well, I will not entirely follow you on the metaphor.
I'm sure you won't.
But
you get my point.
What I would say is, yes, you're right. We don't want the baby thrown out with the bathwater, because this is not a borderline case, whether you take the CMA's approach, which I explained in opening, or the reasoning process of the tribunal, which, as I say, is robust in the relevant respects, which led to its conclusion that all of the grounds of appeal fail. The conclusion is the same, that this is something that this court should not send back for a further retrial, because the concerns about cross-examination on dishonesty at this time were an irrelevant consideration, and shorn of that legal error, there is a defensible decision.
Just before you move on, so nobody says that dishonesty is part of the breach. The tribunal seems to think that because there's an allegation of covert behaviour, that re-engages in some way dishonesty. You say that's a legal error. The mere fact that you allege that something's a nod and a wink or covert is simply part of the evidence going to whether there's an unlawful object. It doesn't engage misconduct or dishonesty or malfeasance in any way. It's just simply part of the evidence going to object. It's that additional label which somehow re-engages with dishonesty, which the tribunal seems to think is somehow relevant.
Yes, yes, absolutely. So, my lords, just to pick up on the Chancellor's comment earlier, there were a number of ways in which the principle of finality could have been respected, even if this were a relevant matter. They could have raised the issue with counsel before the witness was released, possibly in the absence of the witness. They could have alerted counsel afterwards to the concern that there were these evidential gaps in the testimony, because Mr. Dimitri didn't confront him with dishonesty directly, and then debated the matter. And in consequence of that debate, there might have been an invitation for recalling of the witness at that stage. But the point is that the tribunal could and should have taken into account as an input any perceived evidential gaps in Mr. Baton's testimony before it came to that landing crystallised in the H2 judgment.
Yeah.
If they had come down against the CMA at that stage, having done that, you would have had a judgment subject to the possibility of appeal cleanly in the normal way, without the time or cost, or in the Master of the Rolls word, agony that has followed.
Can I just ask something, Mr. Turner? You may need your juniors to assist on it, but the main hearing ended on the 23rd of December 2022. We can see that from the transcripts. But there were then, I think, 2 further days, one in January, one in February, and then something called Annex 3 data provided on later dates in April and May. Can I take it that none of that stuff in January, February, April and May was anything to do with the tribunal raising this issue of dishonesty with the...
I need to check. Yes, I'm assured that those related to the abuse of dominance part of the case.
Yeah, okay. Yeah. Because you got a period of effectively 9 months till the judgment comes out, during the course of which one might have thought that if they had a concern, they'd have raised it.
Yes.
So sorry, H1 and H2 take place together,
Yes, it was a
Yes.
consolidated trial
and then 9 months later you get 2 judgments,
in close
and that's
succession.
the first time you know that you're getting a closed judgment which is expressing these concerns about dishonesty.
Yes.
Except that, of course,
Well,
you've had the argument.
You've had the consequentials hearing.
Well, you've had.
No,
No,
that-
sorry,
No, you've
that
had
was
the
on-
you've had the argument.
You had the
where
argument
Mr.
in close.
Demetrius
Yes.
It goes head to head with
Yes.
the president.
I think
And
I
then it's
got
closed judgment, then
I think I got the dates right. The H1 judgment was the 18th of September 23. The H2 judgment was closed judgment, handed down on the 29th of September.
yes, very, very close to it.
And then there's the consequentials hearing. And it's after the consequentials hearing, they issue H3
Three.
in March of
March,
this year,
yes.
and at the same time make H2 open, but with the stamp on top of it.
Yes.
Is that
When was the
Yes.
judgment? When was the judgment in H3? March.
March
6th
2020,
When was the
March
hearing?
this year.
6th of March, wasn't it?
Yes,
8th of
the
March.
hearing was in November?
Yeah.
October.
Yeah.
Hearing was in October 2023.
Yeah.
And then we expedited it, which is why it's here now.
So you see the sequence.
So they took 4 months, having heard the argument,
Yes.
post H2 closed.
Yes.
They took 4 months to come up in March with or 3 months to come up with the H3.
Yes.
Right. And there was no submissions demanded or anything like that in writing.
There were some written
Well,
submissions we were taken
what-
to, weren't we?
Yes.
No
so
submissions in writing after the oral hearing in November.
The list of questions.
the list of questions which I showed you earlier that the companies put in, for example, you saw that.
Yeah.
That came in after that hearing
Right,
with the questions that they say the CMA's counsel should have put.
right. Chronology,
Yes.
chronology.
Yes, and there were some further submissions on our case that were put in after that Mr. O'Donoghue went to when he was addressing you earlier.
All right.
Yeah.
Now, had this course been taken, had H2 been decided after they had come to a landing on the relevance of this dishonesty issue to the disposal of the case, then had the dishonesty point gone against us at that point, we would have appealed, as I say, on the basis that I have argued in this appeal now, that the tribunal's views on dishonesty and the impact that it legally has on the merits of the case were incorrect. But instead, as you have heard, in H3, in March this year, the tribunal allocates the fault of the way that it went about things to the CMA for having insisted that its counsel's questioning of the witness was sufficient. Now, we touched on that, but if I may take you to it, it's in H3 at page 347 of the core bundle, which is internal page 447.
Yeah.
Which is paragraph.
It's in paragraph 68. I'm looking at the bottom of the page at paragraph 68, subparagraph 2. And this brings together some of the points that this court has already, in argument, referred to. The first point is, at the bottom of that page, the tribunal saying, well, we reflected on whether we should have been more active in the cross-examination, but we couldn't have been without descending into the arena. That's the bottom of the page. And if you turn over, subparagraph 3, you have the point that because the CMA was insisting, as it still continues to do, that it had done everything right, it would have been inappropriate for the tribunal simply to conclude, without considering the actual evidence, that because it appeared the case had not been properly put, the appeal should succeed on purely procedural grounds. My comment is that that's effectively what it has gone on to do in H3, ultimately, where it says, well, we now do say that they didn't put a point and we will reverse this on procedural grounds. And then in subparagraph 4, you see the introductory words. In those circumstances, the tribunal was forced provisionally to decide in the judgment. H2, extremely difficult questions of fact on the basis of an incomplete record. And they say we want to be clear what we mean by this. And in Roman 3, they refer to the conduct of the CMA failing to put a case fully, while asserting the case had fully and properly been put, forced the tribunal's hand, essentially, to decide the case on an incomplete record, leaving over the question of whether the deficiency in the cross-examination of Sully and Bacon was so great as to oblige us to find the conclusions provisionally expressed in the judgment so unsafe that they can't stand. And on this reasoning, we very respectfully submit that it is illogical and wrong. It is illogical because the tribunal could perfectly well have proceeded in the ways that I've outlined, even if it did entertain these concerns about the CMA's position, without ending up in this tangle. Instead, what it has done is to proceed in the way that this court now well understands. It's handed down a judgment which appears trenchantly to uphold the CMA, and, it is true, to make express findings of dishonesty, as Mr. Jowl says, both against the undertakings as entities in their own right. If you go to internal page 91 of H2, you see that. It was paragraph 1532, Roman 1.
Yeah.
And against individuals, Mr. Baton individually. Paragraph 15323A. So it finds the undertakings were dishonest and the individual was dishonest. But then, having done all of that, to decline to give final relief by dismissing the company's appeals against the decision and reopening its assessment of the evidence on the core issue in the case. And as I'll show you in a moment, the tribunal then even uses the phrase, it's open season in the subsequent hearing to describe the kinds of evidential gap that it was inviting the companies to find in the CMA's case. And I'll show you that in just a moment. It leads on to the next question raised by the Master of the Rolls. Why did we, the CMA, not go directly to this court after we received the H2 judgment? And the answer, in a nutshell, is that we hoped to persuade the tribunal that its concerns about dishonesty were wrong, so that it would proceed to finally dismiss the company's appeals, because that would have been the simplest and most cost-effective solution. But that isn't how the consequentials hearing unfolded. As I say, the President suggested at one point it's open season whether we find evidential gaps which haven't been properly cross-examined on by the CMA's counsel. And then, as you know, the tribunal goes on to decide that case, H3, not on the basis of dishonesty not having been put, but on a different basis. So if I may make that good, we go to the transcript of the consequentials hearing, which you find in Supplemental Bundle 7, tab 32 in my hard copy, which begins at page 2566. And in the interest of speed, I'm going to cut through most of these references and ask you to pick up at page 128 internally, which in my bundle is page 2694.
Is this day 2?
This is, yes. Page 1, I'm sorry, day 1. This is the opening debate.
I'm sorry.
So if you have that, it's
hang on
in
a second.
day 1.
I think this is volume 6.
I think it's actually volume 6.
Sorry, in mine it's 7.
Yeah, well, we'll find it. So it's page 128.
128.
Page 2661, I think.
It might have been originally, yes.
Yeah, yeah, okay.
So at the top of that page, just look from lines 2 to 8. This is the President. He says there, he's debating with, I think, Mr. Jones at this point, there's no question of us reopening the findings of fact we made in respect of the evidence that we heard. And as far as paragraphs 24 through to 156 are concerned, that means in the H2 judgment, That sets out our view. And subject to anything the appellants have to say, I think you are right. We are functus. We have dealt with those points, and that is that. And he goes on to qualify this, if you read on, by saying that if there was procedural unfairness, he would revisit those conclusions, but only in respect of the point which was left open in the H2 judgment, essentially the dishonesty concerns. So he says, one takes it from line 16, for those reasons alone, say that although we found on the evidence we heard the cartel infringements to be met, because of these failings we are not so satisfied, and therefore the appeals must be allowed, and to this extent the decision set aside. Now, to our mind, that is neither a setting aside nor a reopening, nor indeed a provisional judgment. What it is an answering of the point that we expressly leave open at 159. So it is focused on the dishonesty concern. And if you turn the page to 129, you read from line 16 to show you the position taken by Mr. Jones on behalf of the CMA. Mr. Jones says, but just in summary, there's a finding in 156 that the grounds of appeal are rejected. There is in 157, the President, yes, all right, we may have a chronological point. Now, clearly, the failure to cross-examine Mr. Baton couldn't feature in the grounds of appeal because the grounds of appeal predate the cross-examination. I think even Mr. O'Donoghue's crystal ball might have failed in that regard. So you're absolutely right, the grounds of appeal fail. But you're saying, I think, we're not permitted, even with an express reservation in 159, to consider a failure, assuming it was a failure on the part of the CMA to put the case in dealing with the grounds of appeal. Mr. Jones makes the point, which I have trailed here. It's because part of the decision on the grounds of appeal, it is part of the decision on the grounds of appeal. And submissions can be made, indeed were made in closing, about the consequences of not putting a case. Those submissions would then be taken into account in reaching the factual findings and in deciding whether the grounds of appeal succeed or fail. So essentially, standing back, the President says you're making just a chronological point because the cross-examination came after the grounds of appeal. And Mr. Jones is pointing out that this is muddled thinking, if I may use the term, because the cross-examination is an input into the ultimate issue you have to decide, which is whether the grounds of appeal should be rejected. And then to complete that point, if you go to page 137 in this bundle, and take it from line 14 over to line 11 on the following page, Mr. Jones says, I'm going to make essentially his submissions in a blunt way so I can be absolutely clear about them, but not meaning to be impolite in any way. I'll say the points bluntly. So if that's what you intend to achieve, the way to achieve it would have been to invite submissions on these points before handing down judgment. I see. Had that been done, the submissions which would have been made their way through into your factual findings, not only into your conclusions, because the consequence of the argument that these are unfair findings isn't one that should make the findings anyway, but then not follow them through. It's that you shouldn't make the findings, and one would have to go about the fact-finding exercise in a way in which you would be keeping in mind the burdens on the CMA. That includes that they've got to properly put their case. If they didn't properly put their case at this point, does that mean I'm going to accept the witness's evidence? Maybe it would have meant that, in which case maybe you would have made different factual findings, but that's not what the tribunal did. So essentially, this is the point which I've sought to repeat today. Mr. Jones was making the point it's not open to the tribunal to revisit your decision on the grounds of appeal, and what you should have done is deal with dishonesty before you reach the landing. And what then happens at this point is the President explains the line he's drawing as to what is now open for debate and what is not. You see that at page 142, lines 11 to 18. This is the President. He says, just to reiterate the line we're drawing, we don't consider it's open to us to revisit the evidential basis on the record. What we can do, in our judgment, we can investigate, as it were, the evidential gaps in the record, those gaps arising from the CMA's alleged failure to put the case it was running, And then he has the phrase, which in my submission is of concern, so that is open season. Now, it's right to say that the gist of the tribunal's concern about what was not put at first is focused on dishonesty, but you see here it blossoms into an alleged failure to confront Mr. Baton with a range of matters, including was there a nod and a wink given to Mr. Patel or not. And in response to that broader concern, what then happens is that Mr. Jones shows the tribunal those passages in the cross-examination where Mr. Mitriou confronted the witness on the common understanding. The relevant passage begins at page 87. Sorry, so I'm going back a bit for this. Begins there at line 10.
Sorry, 87.
87 in this same transcript. So you go back to what?
Again, back.
Yes, I'm sorry, which was perhaps in Lord Justice Green's bundle 2620.
That's right, 2628.
But yes, on page 87, that's where it begins. I'm not going to go through all of this, but I just want to show you two bits of what was at this point shown to the court. So if you go to internal page 96 within it, you have the President asking if there was specific questioning. This is from lines 11 down to 20, or 16 down to 20. The President asking if there was specific questioning by counsel on the communication between Mr. Baton and Mr. Patel, that Mr. Baton would stay off the market if Auden supplied it at a very low rate. And if you go over the page to 97, look at line 22, you see Mr. Jones noting that the question was not put in those terms, but it was the flip side of the threats which were cross-examined on. This is at the top of page 98. If you're threatening the opposite, it's clear the shared premise is that if the written agreement was entered into, AMCO would stay off the market. So now the President asks to be shown this cross-examination on the threats, lines 6 to 8. He said, it's his memory that's at fault. Can you show this to me? So Mr. Jones responds from line 9 onwards on page 98 by showing the President the tribunal, the cross-examination, including the email and the implications of this email on the 15th of June, which the court's now seen. If you go to page 100, a couple of pages on, and look at line 23, he's referring to Mr. Mitriou's cross-examination where she says, line 23 and over the page down to line 5, something that we've now read several times in this court, that this is the premise it was put to the witness, and he says, yes, but I am not saying that to him. This is something that was quoted in the H3 judgment at paragraph 110. But the tribunal's point, so far as one can discern in the H3, is that she should have been clearer than she actually was at this point. But that was the key cross-examination. And then at page 103, if you just look at lines 12 to 19, you see the President asking whether there was cross-examination, because if so, he's forgotten it, as to how Mr. Baton got the increase in supply from 6,000 packs up to 12,000 packs. How did you manage? How did that happen? And Mr. Jones promptly again responds with the key material, and that is on page 107. Just look, 107, line 21, at the bottom over the page. Question: you were telling him that if you didn't do this supply deal, you would come on the market and you could contest 100%. He says, top of the page, I do not think I ever told him that, and this is very critical, but clearly that was the implication of this. So he accepted clearly that was the implication of this. Mr. Mitriou, that's the impression you sought to give him, and so on. Part of the cross-examination you've seen. And I should say that this is not referred to in the H3 judgment. I'm sorry, this one is. I'm at paragraph 112. The ones that are not are the following. Page 109, lines 6 to 10. the cross-examination, you said this expressly to him, even though you were bluffing, it's what you told him. You said, if we don't get this over the line, we'll launch our own product. Looks like I said that, yes. And page 111, lines 14 to 22, where Mr. Dimitri put from line 17, you use the fact of having your own product
So
as
how does
leverage.
this help us looking at it in a sort of remote way? We've seen the cross-examination. Now you're showing it to us as it was submitted back to the tribunal in the consequential hearing. I mean, how does this help us determine the procedural reality? Your submission is simply that you can't bifurcate fact-finding, and you had to make the findings of fact all at one time, and giving you some fact-finding and then saying you can do what he said, which was a rather strange formulation of complete the record, is errant. Maybe it's a principle of finality, maybe it's a principle of due process, maybe it's a principle of something else, but it doesn't seem right, right?
My lord, that's right, and that was going to be the final one that I wanted to show you.
The point. What Mr. Jones was seeking to establish here was that the tribunal's concern that as regards cross-examination on the common understanding point was wrong, that Mr. Dimitri had cross-examined Mr. Baton sufficiently on the common understanding point.
But yes, the point is that what
so the open season point was a false point.
Yes. The point is that it blossomed from dishonesty to open season, and it became a question of, well, was this put, and was this put, show me this, show me the other. And on each occasion, counsel does show the cross-examination.
It's really, it all started off wrong because the president, when he came into court, he said, I'm going to give everybody permission to appeal. And then he said, and we've got to look at what the CMA's case was. And by this point, looking at what the CMA's case was too late.
Yes, and indeed, in the H2 judgment, my junior will tell me if I've got this wrong, I think it's paragraph 91, the tribunal says that the CMA's case was clear, actually, in the H2 judgment. Have I got that wrong?
Yeah.
Paragraph 91. It's rather extraordinary when you remember that that was what their position was in that judgment. To then arrive at the position where you're saying that it wasn't clear.
And all the cross-examining you've just shown us over the course of about 30 pages precedes the statement on 128, where the President says, we are functus. We're not going to reopen any of that.
Yes. Absolutely. No, absolutely. This is all by way of seeking to deal with the Master of the Rolls question to us, which was why did things unfold in this way? Why did you not appeal? I'm showing you, therefore, how at this hearing we approached it, thinking dishonesty was the only show in town, and it then expanded in this manner. One final reference, and I'll leave it, is the President returning to the theme of dishonesty on page 100. 100 in this transcript, internal page. Lord Justice Green, it's probably 2666, where the President...
You said 100. Do you mean 100? Do you mean...
no, I'm sorry. I'm sorry, yes. This will be on the following day.
So
Page 100 of day 2. So this is the second day of the hearing.
Okay.
Apologies.
Don't worry, I thought that was what...
At page, maybe in yours, 2841, internal page 100, you'll see in lines 21 to 22 at the end, that the President says, well, do you not have to say, given what he said, that's the witness, not to put your version of events, but to say, you are wrong. And Mr. Jones says over the page 101, in line 20, essentially, no. It's not a question of saying to the witness, what you're saying it's a lie or it's not the full truth or whatever. You're establishing the point, the underlying point, and looking at the...
Well, that's the point we debated
Yes.
last week. Which is, there can be any number of reasons why a witness says something. It may be misremembering.
Yes.
It may be prevarication. It may be an outright lie. But
Absolutely. So the President has come on day 2 to this point of saying, well, surely you need to confront it in this very direct way. And the answer is no, we didn't have to for the cross-examination to be sufficient. So to draw the strands together, point 1, the tribunal's procedure was back to front, and it is that that's resulted in this confusion. Point 2, that having handed down H2, the tribunal did purport to make final decisions on the company's appeals, and we've addressed the point that its perspective was that it could do that, but at the same time at least leave over the free-floating question of dishonesty on the basis that this was somehow a separate issue from that finding, on which it said in the part of the transcript I've shown you that they considered that they were functus, a chronological point. And that is why, in fact, the CMA did submit strongly that if the case was decided, the tribunal was functus. That explains the origin of the original way the ground was formulated. And point 3, on the most generous reading of this, the tribunal should at the very most have confined itself after H2 to these dishonesty points. And that is where I will now draw your attention to the finality principle as it was expressed by the Supreme Court. And if you'd please pick up the Supreme Court case of AIC, which was decided 2 years ago. It's in Authorities 57, my bundle 4.
this is the airport authority of Nigeria.
That's right.
Yeah.
Judgment given in June 2022. Mr. Jowl referred, without going to it, but that's all right, to paragraph 1. Last few lines of which you'll see on page 2103 says there's no doubt judge has the power to reopen the judgment and order at any time until the order's been sealed. But their lordships go on to say the question raised by this appeal is by what process, in accordance with what principles, should the judge decide whether or not to exercise that power. And for that you go forward to page 29 on 2113 under the heading the relevant principles.
Paragraph 29.
Paragraph 29, page 2113, heading the relevant principles. The court says, as this court observed in Sainsbury's, the higher courts have in a number of respects laid down important binding principles, and then they focus on the principle of finality in litigation, how important it is. Go forward to page 2116, paragraph 35. There is the application of the finality principle in that particular case. The court saying the weight to be given to the finality principle will vary depending on the circumstances. So it is case specific. The proposition that I take from it is the Supreme Court underlining in bold that this is a critical principle for the senior courts. And in the present case, my submission is that this principle, more generally good order in judicial proceedings, requires that the tribunal should not have struck out, at the very least, in a new direction, the open season comment in H3.
If you're right that in analysing H2 as creating a platform only for issues of dishonesty, and if you're right that dishonesty is irrelevant both as a matter of general principle and on the facts of the case, then when you take that away, all you're left with is that part of the judgment which excludes any consideration of dishonesty.
Yes. Yes. And so our submission is, following my Lord, in a sense, the logic that you put to me on day 1, referring to public law considerations, of which the principle of finality may be seen to be an expression, I would seem to be coming back to that, because the first position, therefore, would be that they shouldn't have done this. And if you accept that the findings in H2 on infringement can be detached from the observations on dishonesty and the lingering concern, then one can, as you put it to me on day one, as it were, say, well, that deals with it without the need to go on and consider H3, because they shouldn't have gone down that road. However, the tribunal having gone down
But you don't simply say, insofar as they went down that road, the cross-examination was adequate as a matter of principle.
Yes. I mean, the short point on H3, and I went through it in detail in opening, is that the concerns there that the council failed to put the case properly on the common understanding is misconceived for all the reasons that I've given. Yes. That is why we ask essentially for a ruling at the end of the day that the court upholds our appeal against the refusal in paragraph 159 of H2 to give us final relief because there was a misguided concern about dishonesty. And in addition, we would ask for a ruling that the tribunal's decision in H3 to uphold the company's appeals on the basis which appears there should be set aside for the reasons which are given in our appeal against the H3 judgment as well. So, my lord, I'm afraid, so that did take some time. I turn to the second topic, which in my appreciation is the next most important one, which is the response to Miss Ford on how she's outlined the law in this field, the unilateral point against the conclusion of agreements, and the characterisation of the CMA's case with her reference to the various emails looked at in isolation. One of her principal arguments on Friday and this morning was that the CMA's case was consistent with unilateral behaviour in the eyes of a competition lawyer on the part of each of the two parties who made the written supply agreement. So she suggested that Mr. Patel, he may have been seeking just to incentivise the counterparty, Mr. Baton, not to enter the market by making him an offer which amounts to essentially paying him a substantial value transfer. But that offer, and it's important to recall that that's what it was an offer essentially of uncommercial terms at a 97% discount to everybody else. That offer would have been unilateral on his part, she says. Then you go to the other side of the table. Mr. Baton, she says, may not have engaged with that anti-competitive invitation at all. Now you're in his head. He doesn't look a gift horse in the mouth. He's conscious of what a weak bargaining position he's in. And so there is no subjective meeting of minds. That is how she analyses the legal problem in the eyes of competition law. 2 points in response. The first is that this is a mischaracterisation of the case made by the CMA and of the evidence base relied on both in the decision and at trial. Reductive, the way she explained it. The second, which I need to address, is a point of pure law, because Miss Ford made submissions about the law that are incorrect and which matter a great deal for future enforcement action by the public authority. And that is why I need to put that straight, and will seek to do so succinctly. So I'll begin with the first point, which is the characterisation.
Could you just tell us what she did wrong, as far as the law is concerned, please?
Yes. Do you want me to develop that fully, or simply
No, just
express
tell
it
me
in a
what the
nutshell?
proposition is. Why is she wrong?
Well, the proposition
One
is,
sentence.
the proposition is that to make an agreement with a potential competitor which removes the incentives of that potential competitor to enter the market, because it is essentially paying it to stay out of the market, is in itself contrary on the authorities to competition law. It is an object restriction in the language of case law. And that is why, as I will explain, the original case theory that the CMA had in this case which has been confirmed by decisions of the Court of Justice, and indeed was present before their authorities, is a route that it could have taken. It did not take that route for reasons I'll develop. Essentially, rather than focus on the written supply agreements and draw conclusions, they received the full evidence base, looked at matters in the round, and saw that the case warranted finding that there was a common understanding on both sides of the table from all the evidence that they had, and they put the case in that way. They did not either disavow the correctness of that first case, nor say that it was legally wrong, and it was not. I can come to that directly, my Lord, or I can start with the characterisation of the CMA's case.
Yeah.
I'll begin with that, if I may. You'll recall that in my opening, I took the court to the Court of Justice judgment in the 2004 authority of Bayer, which explains the conditions in which you find a meeting of minds for the purpose of a tacit acceptance in competition law. Lord Justice Green also put that case to Miss Ford on Friday. Not asking you to turn it up.
What page is it?
Well, it's in Authority 6, tab 90, page 3414 for the proposition, at paragraph 102 of that judgment. Shall we open that? Authority 6, tab 90, page 3414. This is the passage that Lord Justice Green was debating with Miss Ford. An agreement within the meaning of what is now Article 101 of the treaty to be capable of being regarded as concluded by tacit acceptance, it's necessary that the manifestation of the wish of one of the contracting parties to achieve an anti-competitive goal constitute an invitation to the other, express or implied, to fulfil that goal jointly. So that's the essence of it. The essential point is that it's necessary to focus on the manifestation, what's conveyed between the parties, which can be through a nod and a wink. Don't inquire into their uncommunicated subjective states of mind. It's enough to see, at least with one party, through what it conveys to the other, that it's manifesting a wish to achieve an anti-competitive goal, and that constituting an invitation to the other to fulfil the goal jointly. And then you can accept that invitation expressly or tacitly, including by conduct. Now, in this case, the CMA's evidence, which it gathered from the contemporaneous documents, as well as from the interview evidence and from conduct, was that there was a meeting of minds between Mr. Patel and Mr. Baton about buying off AMCO with a transfer of value of a very considerable sum to compensate it for staying off the market independently. And it wasn't only Mr. Patel offering money to incentivise Mr. Baton to stay off the market. It wasn't just one way. It was also Mr. Baton manifesting that intention because he actively used the threat of independent entry to bargain for the right price at which he would be bought off. And then the parties sit down and debate what is that price necessary to buy off the threat of competitive entry. Now, my Lord, with Mr. Greeley, you asked whether there was a chronological approach to this problem that was adopted, and he showed you his chronology, which we did not agree. We refer again to the decision itself, because, to reprise, the decision was chronological. I took you through it to focus on some of the main points, but the four essential elements were the legal and economic context, including that it was profitable to share in monopoly profits in this situation, the history, the 20 milligram agreement and Waymade and so forth, what Mr. McEwen said in the interviews. Thirdly, the negotiations with these various emails. And fourth, last but not least, the conduct, the immediate suspension of the Ithaca project in the terms that you've seen. And all of that was taken in the round. It was looked at chronologically. You may recall, in relation to what Mr. Greeley spoke to you about just before sitting down, that I referred to the hiccup that occurred around the point, the end of 2014, beginning 2015, end of 2013, beginning 2014, when the AMCO side thought we are weak. We've got this orphan designation problem, we've got these production problems, we don't have the hand that we thought we had before. And it was in those circumstances, as I explained, that they took certain steps to try to improve their position, including by going back to ESICA at that point. But it was consistent with and taken into account by the CMA. And all of this needed to be looked at together. And the focus, as Ms. Ford did, on individual emails, looked at individually with submissions on what those individually meant, misses that dimension completely. And if I may focus on simply two short extracts in the decision at this point, which we have seen, but which Ms. Ford's submissions did not grapple with the implications of. The first, which we looked at originally, is at page 1182 of the core bundle, paragraph 6.934. Those were the three contemporaneous documents showing Mr. Baton's state of mind. Two of which Ms. Ford took you to in isolation. So if you have that open, 6.934, A, B and C, there are three references there. First of those was the reference to Mr. Baton saying, I'm not keen on a battle, and he's not keen on a battle. That wasn't relied on in isolation. It's part of the context showing that both sides are looking for a position where they can cooperate rather than compete, and it needs to be taken together with the other evidence. Then there's the reference in B to the 15th of June email. I told him that if not, we will launch our own. And you'll recall that the full text of that email, which is at page 1109, if you want to look at that, there most conveniently in the same bundle, 1109. Top of the page in paragraph 6.707 shows Mr. Baton saying, under Rob, if they fall short, they should make up the following month. Having said that, I went in with 12k a month when I knew that Jane had forecast 10 with the view that we would have to negotiate. I suppose I thought I would settle for 10. What is going on there, the natural implication, is that he is using his own sales as the benchmark for deciding what is going to be appropriate or required to buy him off. The natural implication of saying, I told him that if not, we will launch our own, is that the converse is true. It is implying, suggestively, that if he does give Mr. Baton what he requires, that he will not launch our own. It's not a question of formal logic, it's a question of what the natural understanding of that in the context of a commercial negotiation is. So this is not an innocuous email about practicalities, as Ms. Ford described it. It was just as it was explored in the cross-examination by Ms. Demetriou, where she teased out the implications of it. And if I may just refer again to Ms. Demetriou's cross-examination on it for one or two points. In supplemental bundle mine 2, tab 7, internal page 30. So this is...
Sorry, day 3.
This
Or day 2.
is day 2, isn't it? Day 3.
Day 3.
I'm sorry. Day 3, internal page 30. In mine it's 551 for the bundle, and yours it may be 548.
Yep.
When you look at lines 14 to 16, halfway down that page, Ms. Demetriou puts it in, you said if we don't get this over the line, we will launch our own product, yes? It looks like I said that, yes. Now, what we're talking about here, Ms. Ford says, well, that's the second written agreement is all we're talking about. That's not a separate element. The second written agreement is the vehicle, the mechanism for making the value transfer. So it's completely consistent with saying, yes, if we don't get this value transfer, we will launch our own. So it's fully consistent with and supportive of the CMA's case. And then Ms. Demetriou took Mr. Baton to the first interview he had with the CMA, which began on this same page at line 17, you see. Let's look at what you said to the CMA in your interview. And if you go to his answer there, which is on page 35, pick it up at line 14 on that page, she says what you said is to the tribunal, it's consistent with that. You used this, the fact of having your own product as leverage in the negotiations. You used it to get the deal over the line, so you were keen to convey the impression you were ready to launch. That's true, but your position is that that was a bluff because you weren't in fact ready to launch. That's your evidence. And then if you turn the page, you see her her questioning about that. So essentially, she is asking him that you're essentially saying that you use this as leverage, and the threat is that you will come in if you do not get the satisfactory deal. She then went to the second interview with the CMA on page 35, bottom of the page, line 25. And the relevant part from this, which is quoted in the decision, is over the page at page 36, beginning at line 20. What leverage did this give you? I don't know. And then an official of the CMA says you wanted to make him understand it. You must have had a rationale. And he says at the top, yeah, well, I think it was more likely to help him give me some better terms. So it can't be clearer that this is a conversation in which he is saying, I used the threat of entry to get what I wanted. And counsel wrapped this up with a question on page 38, line 10. This was the impression you were trying to convey, and the witness agrees at lines 17 to 19. So when you stand back and look at the CMA's case, it depended on the combination of factors, as I've explained it. Each of these pieces of evidence in combination with the witnesses' answers given amply supported the case. It is not the case, as Ms. Ford says, that this is all about a written agreement which is perfectly innocuous. It was the means for effecting the value transfer. With that, my lords, I'll deal, before we finish, with the point of pure law. Ms. Ford's proposition was that an agreement between potential competitors which incentivises one of them to stay off the market isn't a breach of competition law. You have to inquire into their subjective states of mind. In my submission, that's incorrect, both as a matter of general competition law analysis and most specifically in the pharmaceutical field, where pay for delay has been a particular problem, as the Master of the Rolls has noted, costing the public health services vast sums, not just in this country, and where the Court of Justice has taken pains to clarify the law. To start with the position under the general law, just to give you one reference, in Authorities 7, at page tab 117, right at the back of my bundle, page 4184, you have the Commission's guidelines on applying Article 81.3, now 1013 of the treaty, and there's a section which begins the general framework of Article 101, now Article 101. If you turn over the page to 4185, you have paragraph 15, all of the contents of which are relevant to the issues being debated in this court today. But I'll deal just with the first few lines. The type of coordination of behaviour or collusion falling within the scope of Article 101, as it now is that where at least one undertaking, vis-à-vis another, undertakes to adopt a certain conduct on the market, or that as a result of contacts between them uncertainty as unless the market is eliminated or at least substantially reduced. I'm sorry, yes, I read that wrong. It follows that coordination can take the form of obligations that regulate the market conduct of at least one of the parties, and then this, as well as of arrangements that influence the market conduct of at least one of the parties by causing a change in their incentives. So you can have agreements that are objectionable because they change the incentives in a way that restricts the process of competition.
But according to this, I mean, the invitation to treat is then led by, according to this, influencing the market conduct. So is that the quid pro quo? All you have to see on the other side is conduct which has been influenced.
Yes, and as we'll now see from the specific case law in the pharmaceutical field, here, in a situation very similar to this, the court has clarified that where one party, an incumbent, essentially makes a transfer of value to another, a challenger, potential entrant, sufficient to buy them off, you don't need to go further and look into the states of mind of the participants. All you need to inquire into, as the court says, and we'll see in a moment, is whether you're looking at a value transfer sufficient to remove the incentives of the potential challenger to come in. And so it's an object infringement, and the court is looking at it, as it were, objectively. And to the question you raised with Miss Ford, we're not at this point looking into the subjective states of mind.
Well, we'll see it in a moment, but just for framework of analysis, what are we looking for in terms of the conduct of the receiving party? Are we looking for they don't have to show express acceptance. They show their concurrence through conduct
through the entry into the agreement itself.
Yeah, but they need to do something to distinguish themselves from unilateral conduct.
They do.
If you take the money and you take the supply, and then it can be seen you don't enter, it's an inference that you've been influenced by it at the very least.
It is.
Do you have to go that far, or do you have to go further?
I do not submit you need to even go that far. We'll look at the authorities just now. But what you see is that where an agreement has been made, and therefore an offer, I will give you this value transfer, essentially, which it's better than you entering independently.
But the offer's got to be accepted.
It's then accepted, so you enter into the agreement.
Okay.
That's the deal. So if we turn to, first of all, the Lundbeck case, there you should have an additional bundle of authorities that the court will receive. It's called CMA bundle of additional documents. The Lundbeck case is one of the major pharmaceutical cases dealing with the pay for delay problem.
We got it this morning.
Now, the first point I'm going to make about this is something that Lord Justice Green referred to when Miss Ford was showing the Oxera consultancy document, which was 2001. All of these cases, and Lundbeck is one of the major examples, this is the General Court, much later, this is 2016, September 2016. And if you have that...
So I haven't got it.
Right, it's coming up right now. I must point out.
How did it come?
She's got 5 tabs.
No, did it come? It came this morning, did it?
I haven't got it.
It's probably sitting on my clerk's desk.
I'm told it came electronically, and there should have been a hard copy. It came in both.
Which paragraph do you want?
So it's 414 on page 89 of this clip. These are what, in the language they were using, they described as reverse payments. Essentially, although it looks like it's a supply agreement, actually it's a payment by the incumbent, essentially, to the challenger. The Commission explained in the contested decision, reading at the top, that the reverse payments were particularly problematic in the present case, since the amounts provided for in the agreements at issue broadly corresponded to the profits expected by the generic if they'd entered, the
the market or to the damages they would have obtained if they succeeded in litigation. In such a case, any incentive for the generic to enter the market is considerably reduced, if not eliminated. What's important, therefore, is that in the present case, the amounts of the reverse payments provided for in each of the agreements at issue were sufficiently high to allow the generic to accept the limitations on their autonomy and to reduce their incentives to enter the market with their generic products. So the logic of the General Court is to say that where you have this sort of agreement, this constitutes a sufficient breach of the competition law. The matter then...
That's what the 20 milligram agreement was, wasn't it? Because they bought it back. 800.
I'm sorry, the 20
The
milligram...
20 milligram agreement was one which actually involved Alden buying back the product at a
yes.
much higher price.
My lord, you're right. But even in this, the case at hand, you've seen from the email of the 15th of June that the bargaining takes place precisely by reference to what's the amount of product that we could sell independently, which is going to inform the price. So it essentially fits within this legal analysis. You then have the higher court. This goes on appeal to the higher court. And you see that in your 7th authorities bundle at tab 110. The relevant, this is now 2021, so again, these are very recent cases. But you go in it to page 4082.
Sorry, this is in the original bundle.
It is, I'm sorry, the original bundle, authorities tab, bundle 7, my 7th, tab 110, and the page is 4082. Relevant paragraphs are 134 to the beginning of 136. Only in the interest of time, I'll refer you to 135, just talking about paragraph 399 of the judgment under appeal. But the reasoning here was the General Court definitively found, first, that even though the agreements at issue didn't contain a no challenge clause, it was a settlement agreement, the manufacturers of generic medicines had no incentive to challenge Lundbeck's new patents after concluding the agreements at issue. So it's the removal of incentive that mattered, since the reverse payments, the money paid to them, broadly correspond to the profits that those manufacturers expected to make if they'd entered the market, or to the damages which could have been paid for them if they'd succeeded in litigation. And second, even if those payments were of an amount less than the expected profits, they nevertheless constituted a certain and immediate profit, without those manufacturers having to take the risks that market entry would have entailed. In the present case, such a finding is sufficient to establish that the agreements at issue are restrictive of competition by object. So you see the approach that's being taken by these courts, and to complete the picture, only a couple of weeks ago, there was one further judgment of the Court of Justice, the Servier case. It was handed down on the 27th of June. For that, you have to go back to the clip, the additional bundle that I handed up. And
Tab 3.
tab 3. Go in the clip, tab 3. In it, page, I hope, 304. The relevant paragraphs are sidelined, 198 to 200. Read it. Well, it's talking about one particular agreement between Servier and a company called Kirker, but pick up at 199. As the Advocate General noted in her opinion, by merely finding that the Commission had not established that Servier had granted Kirker a licence at an abnormally low price, the General Court ignored the essential elements of the infringement referred to in the present judgment, failed to examine, in the light of the parties' reciprocal commitments and incentives, whether the Kirker licence agreement might have induced that undertaking to refrain from competing with Servier.
follows that by relying on the fact that the royalty rate provided for by that agreement was not abnormally low, without analysing in the light of the economic and legal context, which gave rise to a sharing of markets resulting from that agreement, whether the transfer of value resulting from the fact that the licence agreement allowed that undertaking to market its product on its core market without risk of infringement was sufficiently large to actually induce Kircher not to enter Servier's core markets. The General Court erred in law in the interpretation and application of the treaty. So again, the essential point is the same, that by this point in the European jurisprudence, what the court is saying consistently now is that to have an agreement where one party pays essentially a challenger enough money to make it worth their while to stay off the market and avoid the risks of competition, that constitutes a restriction by object. Now, Miss Ford, on this issue, said to the court on Friday and developed it today, I quote, "Threatening to enter the market is entirely commonplace. Virtually every generic operator does it." That was day 3 transcript, page 157. If the suggestion is that it's commonplace for generics to threaten incumbents on the market, that they'll come in unless they're bought off, then that information is of interest to the officials sitting behind me in this courtroom. Supply agreements entered into on such a footing between potential competitors are a breach of the law. Now, today, Ms. Ford introduced these 2 new documents to support her proposition that a threat by a party to engage in self-supply or to vertically integrate their operations is just a legitimate negotiating tactic. The first of those was the Commission's guidelines. I don't know if you have those loose.
Yeah.
I'll deal with these swiftly because the comments made by Lord Justice Green in my respectful submission were absolutely on the button.
Which paragraph?
Paragraph 65,
Yeah.
in the left-hand column in the middle. And if you cast your eye over that, in that paragraph, the Commission is saying it considers, when relevant, to what extent customers will be in a position to counter the increase in market power that a merger would otherwise be likely to create. And what it says is that one source of countervailing buyer power that the customer could have would be if the customer could credibly threaten to resort to alternative supply sources like self-supply in case the actual supplier decides to increase prices. And this is a million miles away from the situation in this case, because AMCO is talking to, and indeed it is threatening, its potential competitor, the incumbent, so that it can be bought off from entering the market in competition against it. That is not the sort of vertical relationship that these guidelines are addressing, in which a downstream customer is exercising an outside option of self-supply as a way of disciplining the supplier, keeping the supplier honest. It's not this case. And equally, if we go to her other document, which was the consultancy report from Oxera dating from 2001, this is not focused on the pay for delay issue. She focused on the 1, 2, 3, 4, 5th paragraph in particular. And you'll see from that there that it's dealing in particular, although not exclusively, but it focuses on the situation of undertakings who are no longer manufacturing, if you take it from the 3rd or 4th line, no longer manufacturing the product and have no intention of doing so in the future. You see the words used there. Now, in such a case, there may be lawful behaviour because you may not have potential competitors seeking to be bought off. But the law is, as I've now shown you, in the consistent jurisprudence, which I confess is obviously recent jurisprudence of this court, of the Court of Justice.
So that finally takes me to the last point on this topic. If I may try the court's patience on this, it's Mr. O'Donoghue's point, because he said the CMA has originally framed its case as based on unlawful agreements removing the incentives for competition. And you've seen how that's now dealt with by the Court of Justice. And he suggested that the reframing of the case by the CMA on the basis of more evidence that it received indicated a recognition that the original case was wrong. And you'll appreciate from what I've shown you that my submission is that that is not so at all. It remains a rock-solid basis for the finding of infringement. But what's happened here is that the CMA appreciated that the wider evidence base it had supported the case of a common understanding, including in relation to the oral agreement which preceded the written one by a significant period, October 2012, and indeed the original 20 milligram agreement with Waymade, which was also part of the decision. So there's nothing that one draws from that in terms of it being a move away, and somehow the written supply agreements should be taken as a lawful benchmark so that one is then only hunting for some super added quality that is unlawful. That is all I wish to say on the legal topics addressed by Ms. Ford and Mr. O'Donoghue, subject to any questions from the court. The third topic, which I'll try to broach in the remaining minutes of this hearing, is the response to Mr. O'Donoghue on what are issues 1A, B and C in the list of issues. And this is the question of the CMA's case. Was it adequately explained? Was it adequately put by counsel? The argument from the companies, Mr. O'Donoghue putting this, was that the CMA failed in the decision to explain how the common understanding that AMCO would stay off the market in exchange for the cash differed from the written supply agreements, and that counsel, Mr. Mitru, had also not put that difference in the course of her cross-examination to Mr. Baton. And there are two short points in response. The first one is something I've already now covered, in effect. Mr. O'Donoghue's premise is wrong, that the decision gives the written agreements what's been referred to in this court as a clean bill of health. Even on the footing that the decision by the authority doesn't simply focus on the written supply agreements alone, those written supply agreements remain a big part of the problem in the CMA's decision itself. They are the mechanism for effecting the value transfer, and that is why Ms. Ford's submission that, well, we're only talking here about what would be necessary to get the deal over the line, misses the point. The extent that deal was the written agreement was the basis for the value transfer. So, in this connection, Mr. O'Donoghue also mounted an argument that the written agreement, or at least the second written agreement, contain what he described as a non-compete clause. So you'll recall him using this term. And in his submissions to this court, he says, well, that was a 2-year non-compete clause. Analytically, with respect, that is incorrect. The clause in question, which was 2.2 of that agreement, gave AMCO the right to enter at any time on 3 months' notice. That's it. It's not the same, self-evidently, as an understanding that the money which is being paid across is in exchange for AMCO staying off the market, which, by the way, is not an understanding for some set period. It's not for 2 years, the length of that written agreement, or any other specific duration. So Mr. O'Donoghue asked with a flourish on Friday, we don't know if it was 3 years or 4 years. There's no need to have some specific duration. The nod and the wink could be as loose as we agree that we're not coming on the market while we're being paid. The clause is, however, compatible, clause 2.2, with this common understanding. The two can work together. That leads me on to a further point on Mr. O'Donoghue's submissions, because he suggested, day 3, page 72, transcript, that the witness, Mr. Baton, was never fairly cross-examined because he is not a guru in competition law, and he would not have understood that Mr. Mitriu's questioning about agreeing not to enter the market went beyond these written agreements. So he would have been understandably confused. The answer, in short, is that everyone understood, including Mr. Baton, including the tribunal president at the trial, exactly what the CMA's counsel, Mr. Mitriu, was asking through her questions. If I may give you just one reference that you have not seen, and that is the president's intervention in the cross-examination of the other AMCO witness, Mr. Sully, which you haven't looked at yet. That's day 1 of the trial. So that's supplemental bundle 1. In my hard copy, that's the 6th tab at page 415. It's internal page 100. And you have, at the top of the page, you've got that internal page 100. Question, counsel, what happened, Mr. Sully, is you didn't want to test the market yourself in 2014 because you had a much more lucrative supply deal from Alden. The business didn't want to take the risk of entering the market itself, so it entered into the agreement to take supply from Alden instead of entering the market itself. And both sides knew the score, did they not? So very clear in my submission putting of the case, the CMA, by the CMA's counsel. And then you have the President's intervention in her cross-examination. If you look down from line 20, the President interrupts at that point because he wants to pick up and make sure the witness knows what's meant by knowing the score. And he says, I'll say what I get from that. Mr. Mitriu can correct me if I'm wrong, and you can ask the question. What I think is being suggested is that at the time of the second agreement, both Auden and your company were agreeing, and I'm not saying or suggesting a legal agreement, I'm suggesting an understanding that you would get the product, the Hydrocortisone full label at £1.78 a pack, which you would sell or be able to sell for a far higher price, thereby making a marginal profit which was substantial. And in return for that, you would not enter the market with your own product, whatever that might be. Have I got that right, Mr. Mitriu? Sir, yes. Very good. And the witness says, I can tell you absolutely definitively, that was not the agreement. And he repeats that from lines 22 to 23. So you see there...
Maybe not a guru, but a basic outline understanding.
Yes.
Right.
It's essentially, it's absolutely clear. Is that a convenient moment?
I think that looks like a convenient moment, Mr. Turner. How are you doing?
Well, I will go away and see if I can compress the remainder of the points when we resume.
But you seem to have done quite well this afternoon.
I've covered a lot. I've covered, I hope, the major points that concern this court. The remainder of what I've got is mainly on some of the more detailed issues that were raised in particular by Mr. Brearley, and I will cut those down to the bare minimum. You still have to hear Mr. Professor Bailey on a continuation point.
I'm looking forward to it.
Well, in my submission, that is important.
Maybe we could record his submissions and listen to them like people do these days on 1.5.
I'm going to do a podcast.
Yes, well,
That was a joke.
I understand that. But Professor Bailey thinks that he may take around half an hour,
Perfect.
and I will try to.
And you'll hand over to him quite swiftly.
I'm going to hand over to him quite swiftly, and then I may resume with some final points, but then it can be over to my friends for their replies.
Thank you very much. We'll see you all at 2 o'clock, also soon thereafter as we can get it.
All rise for table.